Hi, everyone. My name is Elise Finney, and I am here with another quick question with our Done with Divorce. And we're just asking an expert a question today. So I'm here today with Karen Kais. How are you, Karen?
Hi, Elise. It's nice to see you and be here with you.
Absolutely. I'm glad you could join us. And the reason why we wanted to bring Karen on, who is a family law attorney, she has her firm, Arlington Collaborative Law, out of Arlington, Virginia. We wanted to kind of really have her kind of shed some light today on collaborative divorce. So one of the questions I have for you, Karen, is as collaborative divorce gains momentum, which it certainly has in the last couple of years, and this we consider it as and I know you would as well, an alternative dispute resolution. What would you say is the biggest advantage of what the collaborative process can be in your experience as an attorney?
Well, Elise, it is exciting to see that it's expanding, and we actually even had a statute that was passed in the last couple of years, basically endorsing the process and outlining the boundaries for the process and what attorneys are supposed to follow while in the process. But one of those things is that we sign a participation agreement at the outset. The clients both sign it. The lawyers and any other team members also sign it. One of the beauties of the collaborative process is that we have the option to use other professionals, the mental health professional, financial professional, and some are neutral in the sense that they're working for both clients and they're not, advocating for one party. So the beauty of the collaborative participation agreement is it outlines the process, it outlines what the parties are agreeing to, and the lawyers and the other allied professionals, mental health, financial, sign off on that as well. So it's a coordinated process. It's an out-of-court process. There's no litigation pending at any point during the process. The professionals that are hired are solely hired for the purpose of helping this couple reach a settlement agreement. And so the team, the use of neutrals in the process, those neutrals can be very helpful because they're seeing it from both parties' perspectives, and they are able to work on the non-legal elements of what's happening. Sometimes it's the emotions or the communications in the room. Some of the mental health people will take the role of a child specialist where they can try to speak for the children in the process. And the financial neutrals are very helpful in gathering information, using their software to prepare reports, helping answer financial questions, getting more information so that we can, move forward in the process, but again, as a neutral. So it doesn't feel adversarial at any point. And it also, those people can help. It's like a holistic team working with the couple, working towards, in most cases, it's a divorce settlement. Another very important element of the participation agreement says that if for some reason the process ends and either of those parties decides to file something in court, then neither of those attorneys would be representing those parties in court. So the commitment really is for the professionals only to work on a settlement-based process. So we also have our meetings very early on where we'll have both parties and their lawyers meet together, possibly even one of the other team members as well, at the very beginning of the case. So this isn't a case where you have more of an adversarial negotiation between two attorneys where, I might never even meet the other party. So we lay a foundation for working together in a very respectful tone and using open inquiry with both of the parties as we progress. So it has a different feel. It also doesn't feel as threatening when you're not in litigation trying to negotiate a settlement. It offers a coordinated team-based approach, and the work is done exploring options. Options are not positions. They're just
Mhm.
exploring different options on any given issue that needs to be resolved. And we look for the clients to help us understand each of their interests, so that as we talk about options, as they put options up, as maybe a team member puts an option up, it helps them and us look at the option and evaluate them based on both parties' interests. Because what we know is if both parties' interests can be met and it's a thought through option, then you're more likely to reach an agreement on
Absolutely.
and what we really try to work towards is something that's a durable agreement, something
Mhm.
that will last over time. In a traditional case where parties are represented by attorneys and possibly they file an action in court, other issues come up and they are more likely to return to litigation to solve problems down the road. We look to create a durable agreement that will last over time, but also create a space so that if those parties desire or need to change something in their settlement, that they
Mhm.
have a venue to return to, they have professionals to return to who are already familiar with their situation, their family, etc. And the studies show that when people reach agreements at the beginning, that they're more likely to go back and negotiate a settlement and less likely to go to court down the road.
Good. Well, thank you for sharing, a lot of light on the collaborative process. So, and then this can be a quick question here, but just to kind of follow up on that, because you mentioned that it's typically is for collaborative law, typically in the case of divorce. What about in a post-modification situation? Can you just kind of give an example of how that can be beneficial to work with collaborative law and a post-modification?
Sure. So, there are some things in a settlement agreement that aren't modifiable by the court unless the parties agree and want to modify it and agree how to modify it. But there are others, particularly those where there is a child who is still a minor. And in that case, there could be a change of circumstances relating to custody, parenting, child support, something relating to the minor child. That's a perfect example where people would return to the process. Or if they never used the process at the outset and they either went to court or they reached a settlement through some other means, they can still use the collaborative process to work through a modification. Now, another would be spousal support. If there is a spousal support and the agreement says that it's modifiable, that means the court could modify it. And also it means that the parties could negotiate it. Usually those elements that are permanently resolved, such as a property settlement, or maybe a spousal support arrangement that is not modifiable by the court per their agreement. Usually people aren't going back to revisit those. However, there still could be a situation where, for example, they've got a provision to sell the house down the road, and then they change the part of the agreement. They both agree they want to change it, so they can negotiate what they want that change to be. And if they enter into a modified agreement, that can then be filed with the court. Another example of that could be something like college, when, sometimes people enter into their settlement agreements. Let's just say their children are, in elementary school and they're not really thinking a lot about college, and when they settle their case, they really don't want to address college in their agreement. But as the children age and get to the point where they're starting to plan for college, they may decide they want to negotiate an arrangement regarding either saving for or who's going to pay for what their obligation is, if any, and getting that reduced to something in writing. And even though this wouldn't be another example, it's not post-settlement, but people are now using the collaborative process for prenuptial agreements and even marital agreements. So some people do not desire to separate, but there's a financial matter they would like to resolve with each other, almost as if it was a prenuptial agreement,
Mhm.
but they're married. And, let's just say they're buying a home and one person's putting a lot of their own separate money into the home, and they want to have some agreement about how that will be owned, what money will be used to pay expenses for it. So those are just a couple of other examples where, even though it isn't post property settlement,
Yeah.
the collaborative process is being used in a family law context. Now,
Okay.
you can use the collaborative process in another type of a case, and it is sometimes being used in estate planning matters or guardianship or something of the like. But today, I think we're just addressing, the statute addresses family law matters, and that's what we're here to discuss today.
Perfect. Thank you so much, Karen. Really appreciate you shedding some light on the collaborative process for our viewers. Thank you.
Yeah, thank you for giving me the opportunity. All right.
Sure.